faithfully observing protocol. I would like to specially recognize the chair of the Chartered Institute of Arbitrators, UK, Nigeria branch, Mrs. Olusola Adegbomire, FCIAB, members of the executive committee, the chair of the corporate and in-house council committee, Dr. Esan, FCIAB, and all senior members and fellows of the Institute present today. You are most warmly welcome. This topic lies at the very heart of arbitration. It raises that timeless question: how far can party autonomy go? Arbitrability defines the boundary between what private parties may validly submit to arbitration and what must, by law or public policy, remain within the jurisdiction of courts or regulators. Today's dialogue promises both depth and practicality. We are privileged to be joined by an exceptional panel whose collective experience spans academia, government, and international commercial practice, each bringing distinct perspective to this evolving subject. Please allow me to introduce our speakers. We have with us Dr. Mauto Tosa, a scholar and practitioner of remarkable caliber, the first African recipient of the prestigious J.B. Scott Prize of the Institute of International Law, whose research continues to bridge academia and practice. His career stands at the intersection of scholarship and practice, where ideas meet real-world resolution. Thank you for joining us, sir. Joining him is Ms. Sarah Fafa-Podo.
My pleasure.
Thank you. Joining him is Ms. Sarah Fafa-Podo, Chief State Attorney at Ghana's Office of the Attorney General and Ministry of Justice, a dual qualified lawyer with over 2 decades shaping Ghana's energy and legal sectors. She is a fellow of the Chartered Institute of Arbitrators and a member of the LCIA Users Council. Ms. Podo has represented the government of Ghana and private clients in major commercial disputes and continues to contribute meaningfully to the development of arbitration practice in Africa. Thank you for joining us, ma'am. We also have Mr. Opeyemi Longe, a senior associate at White & Case, LLP London, whose international arbitration practice spans complex multi-million-dollar disputes across Africa, Europe, and the Middle East. He is a dual qualified solicitor in Nigeria, England, and Wales. Mr. Opeyemi's experience bridges jurisdictions and cultures. He brings to us valuable insight into the realities of cross-border dispute resolution. Thank you for joining us, sir.
Thank you. Pleasure to be here.
Guiding this distinguished panel is our moderator, Ms. Anne-Marie Anyaru, FCIAB. She's the State Attorney at Ghana's Office of the Attorney General, a Columbia University LLM graduate, and a fellow of the Chartered Institute of Arbitrators. She's currently serving as a United Nations postgraduate fellow. She is also an alumna of the Africa Arbitration Academy, where she co-authored and won the 2024 Prize for Excellence in Writing. Her moderation today promises to combine insights, structure, and intellectual grace. Thank you, everyone. We are deeply grateful to each of you for taking the time to be with us here today. So before we begin, before I hand over, I would also like to speak on a few ground rules to make most of today's session. The webinar time will run for 90 minutes. So I am sure our moderator is pleading for me to be done. We'll begin with opening presentation from our speakers, followed by a panel discussion moderated by Ms. Anne-Marie. There will be poll questions, throughout the session for our participants. Please participate so that we'll make it lively and everything would flow in tune. There will also be Q&A session. Please drop your questions. I will curate them and direct them to our speakers. And lastly, please stay engaged, comment, react. Let's make this a lively and thought-provoking exchange. Our goal is to create a space today for honest reflection, learning, and dialogue. I'm confident that our speakers will give us plenty to think about. Thank you all once again for joining. It is now my pleasure to invite the Chair, Corporate and In-House Committee, who has been doing well, bringing out all these thought-provoking topics for us to deliver her opening remarks. Thank you very much. You're welcome, ma'am.
Good afternoon, distinguished colleagues, ladies and gentlemen. On behalf of the Corporate and In-House Council Committee of the Chartered Institute of Arbitrators Nigeria branch, I warmly welcome you to today's webinar on arbitrability in focus, navigating what can or cannot be arbitrated. Today's session brings together seasoned experts who will help us unpack these issues and provide practical insights on navigating the boundaries of arbitrability, which sits at the core of arbitration. It defines how disputes can be resolved privately and which will remain within the authority of the courts. Particularly for corporate and in-house counsel, it shapes how we draft contracts, advise our organizations, and manage disputes. Now, for practitioners and arbitrators, it's also very important. It's central to how they determine jurisdiction and avoid wasting of our time. So I encourage you all to listen actively and engage fully in what promises to be an enriching discussion. As you know, this webinar has associated with it the CPD points. You will get the link at the end, towards the end of this webinar. Please refrain from putting in your personal details, your names, branch, and all the the other details. The link will be sent, will be posted intermittently in the course of this session. Again, thank you for joining us, and have a good time listening to our speakers. Thank you. So over to you, Ms. Anne-Marie, the moderator.
Thank you so much, Madam Chair. Good afternoon, good morning, wherever you're joining us from. Thank you so much once again. We do trust that this will be an enriching and an educative time for all of us. I'll hand over to Dr. Mauto Tosa now, who will lead us just to set the tone for our panel discussion. Over to you, Mauto. Thank you. Thank you, Dr. Tosa.
Thank you so much, Sadiq. Thank you so much, Anne-Marie. Allow me, first of all, to thank Dr. Nike, the chair of the Corporate and In-House Committee, for this kind invitation. You know, Nigeria is the largest economy in Africa, and when law and economy work hand in hand, so I'm facing today the legal power of Africa, and this is both a privilege and the challenge, and I'm so happy and pleased to be with you this morning, even if it is online. So dear colleagues and dear participants, thank you for your presence today as we turn our focus today on a fundamental and yet often complex question of arbitration. What can and what cannot be arbitrated? We will be exploring the concept of arbitration, arbitrability, a key determinant of whether a dispute can be settled through arbitration or be reserved for the domain of national courts, regulators, or even public institutions. What does arbitrability generally mean? Because my point today is just an introduction. So arbitrability is a legal concept of determining whether a specific dispute can be settled through arbitration or not. And it defines the limits of arbitration jurisdiction, arbitral jurisdiction, and the boundary between what is public and what is private in the justice system. So some example, both the New York Convention and the ancestral model law are limited to disputes that are capable of settlement by arbitration. And this implies a clear message today that we should know. Not all disputes are arbitrable. And this also leads us to something that we should make a distinction between what is public and what is private. A balance between both is very important for us as corporate or in-house counsel. So the distinction between public and private in this case of arbitrability exists because arbitration, while private, can have public consequences. And some disputes engage matters of public policy, social protection, or state sovereignty, which cannot be entrusted to private resolution. Article 2059 of the French Civil Code provides that all persons may enter into arbitration agreement relating to the rights that they may freely dispose of. Yet this same legal instrument in its Article 2060 introduces a caveat. Disputes involving matters of public interest, such as personal status or capacity, for example, are not open to arbitration. Similarly, the Brazilian Arbitration Act of 1996 allows arbitration only where the rights involved are freely transferable. So we can see a recurring principle. If the subject matter allows arbitration, so we can have arbitration. So the matter of dispute is so deeply intertwined with public interest. If it is intertwined with public interest, so it may be reserved for court. So what we should know mainly is that national law are those who establish the scope of what is arbitrable. So the arbitrability of a dispute may depend on multiple jurisdictions: the law of the seat of arbitration, the law governing the arbitration agreement, the law applicable to the substance of the dispute, and even the law of the country where enforcement is sought. For example, in some Arab states, agency contracts involving foreign corporations are protected by law and must be resolved by local courts. So let us come now to the type of arbitrability that we can encounter in our practice. We have, first of all, subjective arbitrability. And there is a question you should ask there when you are talking about subjective arbitrability. Can the parties arbitrate? This is the main question. This concerns party capacity. Can a public entity, a minor individual, or a government agency legally enter into arbitration agreement? And this aspect also considers whether the parties involved have legal capacity to enter or to arbitrate a dispute. This kind of arbitrability is called arbitrability ratione personae because it depends on the person capacity. And once again, I give the example of the French Civil Code. Allow me to give this example because I'm from civil law tradition and I'm from a French-speaking country. So French inspires us a lot. So in the French Civil Code, you can see that some disputes involving public entities may not be subject to arbitration. Now let's come to the objective arbitrability. There is a question you should ask in this case. Can this type of dispute be arbitrated? This relates to the subject matter itself. It refers to the actual dispute at hand and whether its substance is appropriate for arbitration. And in this case, we talk about ratione materiae arbitrability. Arbitrability, ratione materiae, which refer to categories of concern that can be arbitrated. So being a truly a matter of legitimate concern, the scope of arbitrability varies according to the place of arbitration to it and by the state in its judicial system. There is a big rationale for non-arbitrability that I guess you know, public policy. And public policy heavily influences arbitrability. It's often the strongest determinant of non-arbitrability. And so we have some common areas for this public policy rationale. The first one, vulnerable parties, such as consumers or employees, are involved. Another point to mention in this case is disputes that touch on core public values or regulatory function. Another point in public policy rationale are transparency and judicial oversight in a certain kind of dispute. So when is arbitrability challenged? This is one question we should ask. Arbitrability may arise at several stages during arbitral proceeding. During the arbitration itself, first, where the arbitral tribunal must assess its jurisdiction. Second, during enforcement, where a court may refuse to recognize the award if the dispute was not arbitrable. And third, even during annulment proceedings, especially if the law of the state prohibits arbitration of that subject.
Dr. Tosa, thank you so much for your insightful presentation so far. I'm going to ask that we wrap up in about 1 minute, if it's possible. We're just running out of time. Thank you so much. Thank you.
Okay. So to conclude, I would tell the determination of arbitrability is contextual, dynamic, and varies from one jurisdiction to another. So while the scope of arbitrability has significantly expanded, especially in commercial and international contexts, limits remain essential to protect the integrity of legal order. So as legal practitioners and scholars, we must remain vigilant. Each case demands a careful analysis of the applicable legal framework, the nature of dispute, and the interests of state. These are the general thoughts I wanted to share with you in order to step in the main discussion of the day. Thank you for your kind attention.
Thank you. Thank you so much, Dr. Tosa. That has been a very insightful brief, albeit apologies. We are running out of time, but it segues us into the discussion. And so I'll ask you maybe to start us off with, perhaps, how would you explain the concept of arbitrability in simple terms? And why is it so important in arbitration?
As I've just said it, arbitrability helps us to determine which kind of dispute is capable of being resolved in front of a tribunal, in front of arbitration tribunal, or if it is reserved for the domain of courts, of regulator, of even public institution. And it's very important because we should notice that not all dispute is arbitrable. And this helps us. Well, why is this important to know the arbitration or arbitrability of a dispute? It's important to save time and resources and not ending up having an award that cannot be enforced because at the first stage of the dispute, it was not even possible to arbitrate it. This is the main interest of discovering the arbitrability of the dispute.
Thank you. And Ms. Poto, if I can come to you now from an in-house counsel perspective, if you had maybe one key takeaway definition of arbitrability for corporate and in-house counsel, what would it be?
Okay, thank you. What is and not arbitrable is usually prescribed by the national law of a relevant jurisdiction. These are sometimes contained in statutes or legal codes, like Dr. Tosa said, in France. For example, in Ghana, the ADR Act, Section 1 spells out in Section 1 of the ADR Act. It tells you that matters of national or public interest, the environment, the enforcement, interpretation of the Constitution, and any other matter of the law that cannot be settled by alternative dispute. So in a brief, whatever I would say that in respect of arbitrability is one to go to the national law and look at what it says. But I would say that there's sometimes a little bit of a confusion where you have two national laws conflicting, and where you have one in the ADR Act, a list the areas of arbitrability, but you have a particular legislation in respect of specific things that the states have sovereignty over, where it's expressed in the law that those matters are not arbitrable. Yeah, thank you.
Okay, thank you. And I think that would lead us into basically the public policy rationale, because there would have to be a basis for which maybe the General ADR Act would provide for limitations on specific non-arbitrable matters, whereas you have legislation that will specifically list out what is arbitrable and not. And so, Mr. Longa, if I can come to you and ask, how would you then define the public policy rationale that limits party autonomy in particular? And how has this rationale evolved from sort of a narrow protection of morals and legality to what we're now seeing now, which is a broader protection of a state's economic and regulatory interests, particularly in modern commercial law?
Thank you very much. I think Dr. Toza said this one very rightly in saying that public policy, is typically a question of state sovereignty. So it's defined by the values of what each state seeks to preserve and guard. And what we have seen, of course, is that originally there's protection focusing on the morality issues and all of that. And fundamentally, and that public policy seeks, of course, to ensure that, for example, there's fairness to participants, to ensure, for example, the mandatory social norms of the society is respected. And which is why a lot of the time you have that public policy insist, in many cases, for example, that these are matters that we want our courts to undo. These are matters that we don't want state courts to deal with. But over time, that has shifted to cover even broader issues, particularly commercial issues, including issues of taxation, issues of insolvency, and competition and all the likes. But what you see through that, I think the trend you see flowing through all of these issues is the fact that states are concerned, for example, about third-party rights. States are concerned about ensuring that the laws, especially the mandatory laws of the state, are protected, and that is what has influenced the public policy rationale over time. But I think I should mention, obviously, that with the adoption of the New York Convention, there's been a systemic shift over time in terms of states becoming a bit more liberal and allowing more matters to become arbitrable. You've seen, and some of them, of course, are driven by the need to make their seats attractive as a seat of arbitration, because, of course, there's an increasing competition in the market, especially knowing fully well the resources and the benefits that a state can get by attracting arbitration in its seats. So this trend has sort of resulted in a growing acceptance of arbitration by other states, and of course the growing infrastructure and the growing popularity has made it more difficult for states to adopt or keep a negative approach to arbitration, especially if they want to participate in international trade and investment to the benefit of their countries. So the point being made here is that there's been a growth in that, and that is because states want to ensure access. And even when, and I think that's the point we'll come back to much later in the conversation, even when you have strict foray into commercial issues like competition law, IP matters, they've then also allowed, provided, of course, the tribunal takes into account the mandatory law of the states for those matters to be settled and by arbitration. So I'll pause there now.
Thank you so much. I appreciate that. I think we're going to just take a quick poll now on the foundations of arbitrability. So Sadiq, if you could help us up with that and read out the questions, just so we have set a fantastic foundation for it. Thank you so much. Sadiq, I think you're muted. If you can unmute. Thank you.
Oh, sorry about that. Thank you, Ms. Anne. Thank you, everyone. Our first poll question is about the awareness of arbitrability foundations. The question goes thus: before today, how familiar were you with the doctrine of arbitrability? We have about 3 answers, and our most voted answer, the first answer is very familiar. I understand it clearly. The second one is somewhat familiar. I heard the term, but do not know the full scope. And the third one is, hold on. The third one is not familiar. This is new to me. So we have the most, even though votes are ongoing, but I think the most voted answer is somewhat familiar. I've heard the term, but don't know the full scope.
Thank you so much, Sadiq. Appreciate it.
Yeah, so the second question goes thus: which of the following best describes arbitrability? The types of dispute that can and cannot be resolved through arbitration, the choice of seat and venue in arbitration, the process of appointing arbitrators, and I'm not sure. And this one, the most voted answer is the types of disputes that can or cannot be resolved through arbitration. Over to you, Ms. Anne.
Thank you so much, Nick. Much appreciated. So I want us to hopefully move on to the limitations and the boundaries. So we've identified that, you know, under the New York Convention and the Unsatural Model Law in particular, provision is made for matters that are not arbitrable. Ms. Podo, if I can ask you, why do you think legal systems place limits on arbitrability? I know Dr. Tosa sort of outlined some of the public policy concerns. Would you like to shed more light on?
Hello, can you hear me?
Yes, Ms. Podo, can you hear us?
Yes, I can hear you.
Can hear you.
Yeah, my camera, I think it's where I am. Okay.
Okay, sure. Would you like for me to repeat the question?
If you can, please.
Fantastic. So I was saying that we've heard from Dr. Tosa that under the New York Convention, the model law, a lot of our state legislation provide that some matters are not arbitrable, and we're going into a gray area of non-arbitrability. Would you perhaps like to shed light on why some legal systems place limits on arbitrability? Maybe some of the public policy concerns. Dr. Tosa listed some, but I'm wondering if perhaps you'd want to expand on any.
Okay, I would take it from, for example, from the Section 1 of the ADR Act. I mean, for example, taking constitutional reviews, I see it being of a national concern where you have a judicial review based on an interpretation of a constitution where that is going to arbitration. Definitely the arbitral tribunal will not have jurisdiction over that. Matters of also of environment. Basically, it affects the environment of particular jurisdiction. So taking such particular issue to international arbitration would the tribunal will not have jurisdiction. Also, there is an issue or where there is also a matter of taxes, where the state will always want to have that sovereign right to determine what taxes people either doing business in the country or people staying and living in the country do at taxes. So, I mean, I think in one line, if I would give it a word, is matter of sovereignty for the states and not having matters that they have to adjudge being taken to arbitration.
And so such matters should remain the sole preserve of the national courts and not be relegated.
Of the national court and not refer to arbitration.
Thank you so much. In furtherance of the limitations or the gray area, Dr. Tosa, if I can come to you and ask you perhaps for a clear understanding, because you mentioned briefly in your presentation about subjective arbitrability versus objective arbitrability. And that dichotomy. Can you please perhaps explain further, if it's possible, and help us understand which of these is more frequent and costly as a challenge in international arbitration?
Okay. Thank you so much for the question. I think I have given some insights about subjective and objective arbitration. Starting from subjective arbitration, I said that it concerns some individual and entities. It may be individual or state entities that are deemed unable or sometimes able to submit a dispute to arbitration. This is subjective arbitrability. Is the party has the capacity to submit a dispute to arbitration? The question we should ask, and it's ratione materia. Very important. Ratione persone, I wanted to say. So now the objective arbitrability is ratione materia, the subject matter. Is the subject matter arbitrable? That's the question we should ask. And in my presentation, I've given some points, some areas, common ground for to contest arbitrability in some situations. Now, which one of those arbitrability types is more invoked in arbitration? I think the objective arbitrability based on some issues or topic or ratione materia are those who are invoked in arbitration. Most of the time, that's what we encounter and raises most challenges, more than the subjective arbitrability, which is less difficult. It's less difficult to find an answer to a person who is capable of introducing an arbitration claim or not. So the objective is the most encountered in international arbitration, raises more questions and is more costly because it's the most encountered.
And it will certainly set parties back if you that matter that suddenly you find out is not arbitrable. And so, Mr. Long, if I can ask, in your view, and perhaps even in your practice, perhaps what are some of the risks a party could face when trying to arbitrate matters that are clearly non-arbitrable? So we know that arbitrability is jurisdiction specific. And so you can go to, state A and a matter is arbitrable, and you go to state B and it's not arbitrable. Perhaps if you could shed light on maybe your view and even your experience, if you've encountered anything like that.
Thank you very much. I think I probably just want to say something before I go into the risks, and that is to actually put in context the significant advantages that you can get when you arbitrate, and that will be familiar to many of our audience today, that many countries are now parties to the New York Convention, which is more like the fundamental and the backbone of cross-border international arbitration. And because of that, it means that you can take an award from Ghana, and if you know there's an asset in New York, you can go enforce, and there's an ease of enforcement that comes with that, because of the signatories to those that convention by many countries. But then, of course, that then comes up when we talk about the issues of arbitrability. What happens where you somehow settle disputes that are not arbitrable, what are the risks? And I think the very obvious one that comes to mind will be the difficulty with enforcement. And I would say the second, but of course related to difficulty of enforcement, is the wasted cost and time in the process. And if I start with the very first and obvious one, the difficulty with enforcement. So the ultimate outcome of the process is to get an award that is enforceable. In fact, as a matter of course, tribunals have an obligation to ensure that they render an enforceable award. And so, where you do have a situation where, for whatever reason, a tribunal issues an award on a dispute that is not arbitrable, then risks abound. And the first one, obviously, is that once the award is issued, you consult lawyers typically for situations where parties are not willing to abide by the outcome of the award. You can initiate proceedings to set aside the award at the seat of the arbitration. And because in most legal systems, especially those who are, of course, also signatory to the New York Convention, they allow the court of the seat to set aside an award that emanates from a dispute not capable of settlement by arbitration. And I think we've talked about, obviously, the fact that there's a bit more flexibility in different jurisdictions. So there's the fact that, of course, the fact remains that in certain jurisdictions, specific matters are not arbitrable. So where you do go that route, those awards can be set aside. And the second leg of it is that even when it's not set aside at the seat, when you then seek to enforce, when you seek recognition in a foreign seat, like, and I give you the example of an award in Ghana being enforced in New York, when you get to the New York court, the other parties can, of course, also say, well, you should not recognize it because this is a matter that is clearly non-arbitrable. And that's also something that parties negotiate, and that's something that's also clear under the New York Convention, that state courts can refuse to recognize or enforce awards that are under the national law are unenforceable. So those are very obvious risks, and that is why, for example, you have to take proper advice at every stage of the proceeding, whether in fact before you commence your arbitration, to check such that you don't get an award that ultimately becomes valueless. And I'll just wrap up with the second point, which would already be obvious from the enforcement risk that I set out, which is the cost. Arbitration is can sometimes be an expensive process, and so if you do incur costs to get an award and ultimately spend even more time and more expenses to seek enforcement, that is money that the company could have been used could have used to grow, to pay salaries, and in fact management time that could have been used to develop the company. So those are, I think, very obvious ones that you take into account when we talk about the risks that you face when you settle disputes that are not subject or that are not arbitrable.
Thank you so much. And just to echo that, indeed, we should check both, maybe perhaps the law of the arbitration agreement and the law of the seat as well, so as to avoid sort of going through the whole process and, as you said, having an award which at the end cannot be enforced. I want to move on slightly to case studies or examples, perhaps, of these gray areas that we have. Dr. Tosa, if I can start with you, please. We know that taxation, so while, arbitration or matters of arbitrability are jurisdiction specific, there are some common themes. So we know that, for example, taxation and employment disputes are often cited as non-arbitrable. Are there examples of countries which have allowed them in your studies?
Okay. Thank you so much for this question. I think in a judgment of 2016 in Nigeria from the Nigeria Court of Appeal named ASO Petroleum and the NNPC, tax matters are not arbitrable. Tax matters are not arbitrable. But in my studies, I discovered that in Kenya, for example, the Kenya Revenue Authority has set up a platform for resolution of tax matters dispute, tax-related dispute through ADR, including arbitration. And there is another document I discovered that in a report on leadership and public financial management in the world. This is a document that talks about taxation and report about how disputes are resolved in this field. 95% of tax-related disputes are resolved through arbitration in Canada, example, and 85% in Australia. And when we come back to Africa, South Africa sometimes even go through arbitration to have its tax-related dispute resolved. So there are countries that thinks this has big benefit. Arbitration has big benefit in the field of tax matter, even if most of the country think it is non-arbitrable. And there are many international organizations, such as the European Organization for Economic Development, that it asks countries to make an effort in order to resolve tax matters through arbitration, that it will be better for the businessmen and the country's economy as a whole. So I think these countries are given some example where, once again, it depends on every jurisdiction decision to make the issue be resolved through arbitration or not.
Thank you so much. Ms. Poro, if I can ask you perhaps.
Now, about employment, the point about employment sure. Dispute. In Saudi Arabia, the Saudi Arabia labor law clearly say that some disputes involving individual employees can be resolved through arbitration, in which setting in front of the Gulf Cooperation Council. So this is one example. And another example, Belgium and Denmark. Those countries allow arbitration for certain type of employment dispute, generally for high level and managerial position employees. So those are the examples that I can mention in the
Thank you so much. That's broad. Such a wide variety of countries. Ms. Poro, if I can ask you perhaps to weigh in on a Ghana's perspective, if we have any issues on arbitrability and tax in particular in Ghana.
Okay. The Tax Administration Act very express that matters of tax are supposed to be referred to the National Court. But then you have the ADR Act that lists matters that are not arbitrable. And it's not expressly stated in the ADR Act. In the ADR Act, it gives you the matters of national interest and all that. So there is that argument where also in some of the agreements we've entered into with international bodies, where some we have given tax exemptions to these bodies. It becomes an issue where you have an arbitration clause in these agreements. And so that a matter of tax issue arises and you have an arbitration clause in, let's say, a petroleum agreement. And so the issue becomes whether it is the Tax Administration Act that will govern the dispute, or the ADR Act. So we had situations where some of the international oil bodies have taken Ghana to the ICC on tax matters, and they've won on these tax matters. So you have the Tax Administration Act that's explicitly stated that matters of tax, you definitely have to go to the National Court. There is a tax appeal board that has been set under that Revenue Administration Act. And but yet you have agreements that says that the matters of dispute should go to arbitration. So I would conclude that yes, tax matters. If you go under the Revenue Administration Act, matters of tax, it's strictly to refer to the National Court. But we have instances where you have an agreement where you've agreed to arbitrate on issues arising out of an agreement, and tax is one of them. Those tax matters have been referred to arbitration, and the parties involved have won against the government of Ghana.
In your experience in such matters, then, has it been maybe an element of the tax dispute or the determination of, for example, the commissioner, that which would ultimately be arbitrable or non-arbitrable under the Tax Act? Or it's almost
Can you repeat the question again?
I'm asking how we can distill the differences between, for example, tax disputes which are non-arbitrable under the Tax Act and somehow become arbitrable when you go to international fora. I'm asking, is a particular, like an element of the dispute, an element of the tax, the tax decision or the decision by the Commissioner General himself or herself that is arbitrated? Or is it a particular element?
No, it's an element in the tax, not a decision.
So you're able
not
to
a decision.
distill. Okay, I just wanted that clarification that you can distill.
Oh yes, it's an element in the tax.
Okay.
For example, there is an issue of a branch profit tax, which is an element in the tax, but not a decision of the commissioner. So I want to clarify that, not a decision of the commissioner, but element.
Thank you.
Yes.
Sure. So moving on to other areas, Mr. Longo, if I can ask you in particular, from your practice in international arbitration, which areas in the gray zone, and we are seeing that there's a gray zone, so in elements of maybe like IP or employment or competition in particular, often give rise to challenges, and how are tribunals handling them?
Thank you. Of course, like you mentioned, I mean, those zones are gray zones, and obviously, in fact, in many cases previously, they were considered non-arbitrable, obviously for reasons that some of them impact third parties and things like that. But those things are changing, and if you look at competition law dispute between parties, for example, which are increasingly being resolved by arbitration, even where competition law issues are not at the heart of the dispute, parties understand obviously that you can. There's a clear possibility that you can raise competition law arguments in commercial arbitrations, and at the same time, the tribunals are also conscious that if you make an award that touches on those core issues that relates to that are non-arbitrable, they might be challenged. For example, if you render an award that gives effect to anti-competitive behavior, that's one obvious examples where a national court might set aside that award. So with this kind of interface between arbitration and competition law and specific issues that might arrive within the context of employment, for example, you just have to be alive to those issues and also have a clear idea when you're devising your arbitration strategy. So, and I stay on this point. So, for example, when you have a party who challenges the exclusivity clause in a licensing agreement on the basis that it has an anti-competitive effect, it might happen that a party may allege, of course, that the opposing party abused his dominant position during the negotiation and performance of the contract, or there may be disputes on the scope and enforceability of non-compete clauses there, particularly, and we find this in the context of a joint venture or distribution agreement. So the point there is that tribunals, in dealing with them, of course, are conscious that first, there's a possibility that you might stray into giving decisions that ultimately, under national laws, you shouldn't go into, and therefore On the other hand, you have courts in some countries that allows you more leeway in making such decisions. For example, I'll mention in the US and England, for example, there's a long accepted position that competition law issues are arbitrable as long as the parties have considered to arbitrate them and the arbitration does not deprive the parties of their substantive rights under national competition laws, or that it does not prevent the courts or competition authorities from exercising their regulatory and supervisory functions. So those are areas that an award or a decision should not stray into. Otherwise, you are in those zones where you run into problems. And so a lot of the time now, because the tribunal recognizes that they have that obligation to ensure that they have an award that is enforceable, they are very careful to listen to arguments and ensure that in rendering an award, for example, they take into account binding and applicable national laws and regulations when rendering their awards. Obviously, because where a party is not satisfied, they can then seek to challenge. But once a tribunal has carefully considered applicable national laws in those contexts, they might be able to mitigate enforcement challenges.
Okay. Thank you so much. So we're running out of time, so I'm going to ask one final question per panelist, and I'll ask that we have 2 minutes to quickly give sort of an overview, hopefully. Dr. Sos, I'll start with you. Looking ahead, would you consider that perhaps globalization would expand arbitrability further? Or do you foresee that public policy will carve out more exceptions?
Okay. Let's start by saying that international arbitration is a field, is a field par excellence of globalization. But when we take globalization today, it's evolving to regionalization in other countries. Example of Africa. Also, Africa is having its own rules. Why? Because it thinks we should have our own dispute settlement rule and substantive protection of investor and foreign businessmen. And the focus now in the document are on public policy measures in order to develop our country. So I will say that globalization is likely to expand arbitrability, but there is still public policy measure that will hinder this arbitrability. And I think this will depend on what every country think about itself and what it wants in the field of business. Thank you so much.
Thank you. It's fantastically answered. Ms. Polo, if I can ask you, please. As a chief state attorney at the Office of the Attorney General, you often encounter agreements with arbitration clause. What mistakes have you identified in some of these agreements that have led to maybe the awards, or even sort of what mistakes have you come across or have you identified that leads to these pathological clauses? And what are some of the things an in-house counsel can do to avoid falling into these pitfalls? Thank you.
Okay, thank you, Anne. One very important thing I would say is in drafting these clauses, you have to use very clear and mandatory languages that impose a contract obligation to arbitrate. You have to ensure that the language is it's consistent. You have to avoid using ambiguous languages. Some of the past arbitration clauses that we've identified, sometimes I don't even mention the seat. So definitely the first thing that when you're drafting an arbitration clause is one, the language of the arbitration, the seat of the, that's very important. Very simple, very key. It must also clearly define which disputes the dispute that you intend to arbitrate, not have like a double sort of a clause where you're trying to have arbitration and also a litigation in the same clause as well. Also, you have to, if it's an institution arbitration that you're opting for, you must have the name institution in the arbitration clause for clarity's sake, and also consider when drafting if there's going to be some carve-out clauses that you want to. You have to bear in mind those carve-out clauses and then the ramification of those things very carefully. Also, when you choose an institution, maybe there are certain applicable rules and laws that are supposed to be there. It would be good to also mention. One thing you don't do is you don't put in a name arbitrator in your arbitration clause. That is it. And for some of the mistakes that I've seen with government contract, we normally have as a state being sued and most of the time not us taking people to arbitration. And so I would say that one of the things that state councils or in-house councils have to be very cautious of when drafting application is your language of arbitration, your chosen institution, the seat of arbitration, and sometimes you have a venue in arbitration. People are confusing that to be the seat of arbitration. So thank you. I think I've gone over my 2 minutes.
Apologies. We're crunched for time. Now, Mr. Longe, your last question, please, if I can. So we know that you're a dual qualified lawyer in the UK and Nigeria, both of which have recently enacted, new arbitration legislation. Now, I want to focus on Nigeria in particular, and the National Industrial Court, which has exclusive jurisdiction over employment disputes. Are employment-related issues considered arbitrable at all? And if so, to what extent?
Thank you. I'll caveat this by saying that, of course, I'm dual qualified, but less active court litigation in Nigeria because I'm speaking from my room in London.
Sure.
So with that caveat out of the way, yes, if we look at it, generally we, as a matter of law in Nigeria, there's a general, some matters are clearly out of scope. But when we talk about employment, like criminal matters, bankruptcy matters, and that's something common in other climes. And of course tax. Like Mauto mentioned at the earlier. But when we come to employment, with the National Industrial Court having exclusive jurisdiction on employment matters, there's a question of whether that automatically means employment disputes are non-arbitrable. So when you look at it from a literal interpretation perspective, what that Section 254C of the 1999 Constitution as amended sets to do, in my view, is to give exclusive jurisdiction to the National Industrial Court on certain matters, which includes employment, industrial relations, and the likes, to the exclusion of other courts like the Federal High Court, the State High Courts, and what have you. But we have seen, in terms of the interpretation by the courts, and when I was preparing for this, I consulted and I saw there was a 2024 decision, for example, in Udom Report and Communication Network Support Services Limited, where the court took the view that by looking at the provisions of the Arbitration Act and its definition of commercial, employment matters cannot be so defined, and therefore that's not something that is subject to arbitration. Of course, the court, sorry, I forget I'm not before a tribunal. The court also mentioned that the arbitration clause in that case was vague. And so on that basis, the court concluded that that was something that was not subject to arbitration. And interestingly, I want to mention one thing that the court said by noting that people should not be treated like inanimate commodities, capital, or another mere factor of production or resources or as items of commerce. So that's one way of looking at it. And when you then reflect on a decision like this, even more globally, views are different, right? Because in some jurisdictions, the concern is we determine whether an employment matter is arbitrable if, for example, fairness can be guaranteed, if, for example, an employee can have access to arbitration. And we've talked about, for example, how expensive an arbitration can be, and other matters to make a decision as to whether or not employment matters are arbitrable. And of course, the question will be that whether or not the court's decision would have been different if the court was looking at, for example, a dispute arising between a senior managerial officer or, say, for example, a CEO of a bank and his employer, whether that view would be different. Unlike when you're looking at a civil servant before a state ministry of commerce, for example. So, but what we already see is that there's a clear direction as to the fact that employment matters cannot be in that class of matters that are typically expected to be subject to commercial arbitration. And of course, without any criticism to the court, the indication, of course, is that the court is very jealous to protect its jurisdiction under the Constitution, and you can see why that approach has been taken. And I think I would just end by saying that we will hope to see how that jurisprudence develop and how, based on how many more cases the court decides in the years ahead.
Thank you so much for that enlightening explanation. Thank you to my panelists. We have some time now, so I want to use about the next 15 to 20 minutes or so reading some questions, and hopefully we can answer them. Sadi, could you help us out with some questions, please?
All right, thank you very much. Thank you to our speakers. Thank you, Ms. Anne. Some questions are coming in now, but we'll start by projecting some questions I choose. This question by Olali Emmanuel: what is the consequences of plea bargaining used more frequently now in criminal prosecutions by law enforcement agencies with respect to the concept of standard non-arbitrability in criminal matters?
Dr. Tosso, would you like to answer that for us, please?
Maybe the practitioners will be better suited to
answer that. I can take that.
Okay, would you take us through that? Thank you.
I can take
my
that.
scholar's view. I will give that to Ope to talk about how he does that.
So yes, I mean, I think plea bargaining, actually we need to put it in context. Plea bargaining would typically, occur in the context of criminal matters, right? Whether the state is suing or prosecuting a particular individual, or sometimes even before prosecution, there might be plea bargaining. And so you also have to put that in context of the national jurisdictions, what is allowed. And what does happen in practice is when you have an ongoing criminal prosecution, that tends to be that you have that agreement sanctioned by the court. So I think it's something different. This is not something that would normally occur in the context of a commercial relations. So that's not something properly suited for when we talk about commercial arbitration. Obviously, when you're dealing with a plea bargaining agreement, of course, there might be questions of whether or not should there be an arbitration clause included in the event of a dispute arising under a plea bargaining agreement I signed, if that were possible. But I think fundamentally, as a matter of concept, that would be something that you cannot have a panel of tribunal sit on. It would typically be something for a state court to decide on, because those are actually matters of crime under national laws.
Sure, and that still falls under the public policy perspective and the powers of the court to guard certain issues. Sadi, can you give us our next question, please?
Okay. The next question is, good afternoon, moderator, Ms. Andrew. Why is it that election petition matters are not arbitrable under the Nigerian legal system?
Dr. Ope. Sorry, Mr. Ope. I think this will be your forte.
Yes, I think that's an obvious public policy exception. In fact, it's so public policy that there's a special court, there's a specialist court created for election petitions in Nigeria. I mean, just imagine for a moment that, and put in context the fact that arbitrations are meant to be private, confidential, and all of that, and are decided by private individuals. And then you have a tribunal of private practitioners deciding, for example, who becomes or who is the duly elected governor of a state, or who is the duly elected president of a country. I think that screams a no-go area when it comes to arbitration, and I think that is very obvious. And of course, there are other issues, for example, in terms of the need for clarity in development of the judicial system of a country on election matters, and we can go on and deal with so many other reasons why that cannot, or that is currently not a matter that is subject to arbitration.
Thank you. Sadiq, can we go on?
Yes. There's this question that keeps coming up, so let me go ahead and read it from Mr. Ambrose Onyemakono. Can an arbitral tribunal still have jurisdiction over a contract where the respondent sets up a defense of illegality in the performance of the contract leading up to the dispute? I have projected the question.
Where the respondent has set up a defense of illegality. Mr. Longe, I think as a practitioner, would you still like to take this for us?
Of course, I am very happy. And again, obviously, I think I'll start by saying those are matters that are jurisdiction specific. So, for example, if you look at under the English system, as a matter of law, when you raise a defense of illegality, a defense of corruption, the courts have considered, for example, that even corruption does not automatically vitiate a contract. There has to be, and you see, because as a matter of law, they draw a distinction between when you have, for example, subject matter illegality or subject matter corruption. So, for example, you have a contract that allows you to pay bribes. Those are examples where the English court will say, no, we will not enforce. But when you talk about issues of illegality in the performance, so if the contract itself, the subject matter is properly fine. So I'll give an example where you have a contract to build dams, and there are issues of corrupt payments, whether in the procurement of the contract or corrupt payments in facilitating people who are involved in the project. There are remedies that the tribunal can grant. So it doesn't automatically render or prevent the tribunal from adjudicating on it. It, however, allows the tribunal to take into account the arguments. So whether, for example, and factor those arguments into how or the ultimate decision that it renders. So it might be that the tribunal takes a position that that contract is vitiated, and I speak subject, of course, to the applicable national law. So there are different approaches by national systems. Or ultimately, if the court finds that that contract is then unenforceable, it might also, allow for compensation for the party at fault. So it's a question of, again, what the national law talks about, and so we need to sort of always be aware and consult to be certain, depending on what jurisdiction the contract is being performed, or what jurisdiction you have as the seat of the arbitration. So a number of things might be relevant in that context.
Thank you so much. I have one question here for Dr. Tosa, if that's okay. And it's on the public policy. So Dr. Tosa, if I can just, how can you balance public policy and arbitrability of a matter, especially where arbitration is chiefly based on the agreement of the parties? Does public policy override the agreement?
Yeah, as I've just said it, arbitrability mainly depends on what a jurisdiction thinks or a country thinks about its judicial system. Will public policy override the arbitration agreement? It will depend on what the arbitration agreement said or what the instrument, basic instrument, says about that. If there are ground of public policy that think so, maybe it will be possible. But it is not. If it's not something that is set up by the jurisdiction, I don't think it will be possible. I don't know.
Thank you. I was just going to say, Mr. Longa, do you have anything else to add to supplement Dr. Tose's answer or response?
Because I missed the initial part. Can you just clarify the question?
The question was on public policy and arbitrability, and how is it possible that even though the parties have agreed to submit their dispute to arbitration, public policy may still prevent or prohibit the disputes based on its subject matter or any other sort of limitation?
I think the practical thing I would say is actually a question of practicality, because even when we say arbitration is enforceable, by who? By the courts, right? So, and that comes back to the point about if a national system says we won't allow matters of crime to be privately decided, those are matters that the courts have to deal with. We won't allow matters of insolvency because it affects millions and millions of people. Those are matters for the courts. I think that's a practical point about the fact that ultimately any award has to be something that you seek enforcement from the court, especially where parties fail to comply voluntarily, and that's not uncommon. So I think that's one practical point that I would just add, in addition to the point made by Dr. Tosa.
Thank you so much. We have a drafting question now. Ms. Poro, if I can ask you, must one appoint an arbitrator from an arbitrator body for the arbitration? Sorry, must one appoint an arbitrator from, let's say, the arbitral body for the arbitration conducted therein to be valid? If evidence of the arbitration comes before a court of law, or are disputants free to appoint anyone to arbitrate their dispute?
Hello.
Hi, Ms. Poro.
Can you hear me?
Yes, we can hear you now.
Oh, okay. Okay. Yes, one can appoint an arbitrator, especially depends on the subject matter that is being arbitrated, because sometimes the arbitration is of a technical, it has a technical connotation to it. So you need an expert arbitrator so it's not a matter of picking an arbitrator from the question again. You said, can one pick an arbitrator from?
So the question is,
Can you appoint
from arbitral body or are you free to, are the disputants free to appoint anyone? But I think your answer was pretty clear. Hello, Ms. Bodo.
Can you hear me?
Yes, please. We can hear you now.
Okay.
Did you want to supplement your answer? I think.
Anne.
Hi, Ms. Bodo. I think we're having a technical issue on your side, maybe with the network. But yes, arbitrators, parties are free to appoint their own arbitrator, particularly perhaps if it's, subject matter specific. Arbitral bodies would also tend to have a list of arbitrators based on, technical expertise. And so the parties, depending on the
Anne, I think I'm back on. Can you hear me now?
Yes, Ms. Bodo, we can hear you.
Okay. Okay, I just moved from where I'm sitting. Yeah. I just moved. Yeah. Okay. So arbitrators are free to appoint their own special arbitrator. If it's it depends. If it's a sole arbitrator, it will be one arbitrator. If it's 3 arbitrators, whatever the arbitration clause states. If it's 3 arbitrators, each party will have the opportunity to pick its own arbitrator, and then out of the 2, there will be an arbitrator picked as the president. So parties are free to appoint its own arbitrator. And then sometimes to the institution, if it's an institution arbitration, the institution will have a list of arbitrators that the parties can choose from. Can you hear me?
Yes, we can hear you. Thank you so much for that.
I'm sorry, I'm catching a flight in about an hour, so
that's okay.
I'm so sorry. I told you. Yeah. So yeah, okay. Thank you.
Just to let everybody know that the link for the CPD points has been posted into the chat box, so you're free to click on that and refer to that for your purposes. Sadiq, can we have a few more questions, please, just before we wrap up? Thank you.
So there's this interesting question from Andrew. How effective is the usage of arbitration in the dissolution of marriages under the Act?
Dr. Tosa, would you like to give us perhaps an overview? Or if there are any maybe case studies or countries in which family matters.
Yeah, I think in my presentation I said matters like family law, matter of family law are not arbitrable. So is the use of arbitration in the dissolution of marriage effective under the Act? I'm not sure the Act have provided something like that, because I don't really think that arbitration, I don't know what it is about Nigerian law, but in my country, for example, there is no possibility of usage of arbitration in dissolution of marriage. And in my presentation, I've even mentioned that there are generally common ground for non-arbitrality. So it may depend on the country, but in mine, it's not possible. It's not possible. It should be in front of the court.
Thank you.
I'll just mention that I agree with what Dr. Tosa has said, and that's obviously because of the public policy aspect of it. For example, when you're dealing with marriages, because these are matters consummated under the Act, depending on what jurisdiction you're dealing with. And sometimes the question is what relief you're seeking. For example, it might involve, for example, a determination of custody of the child, or for example, actually determination of question of paternity. So typically those are matters that are reserved for state courts. And of course also, and like I said, there's the aspect of enforcement part of it, that, for example, an arbitrator can only give an award. That's how much they can go. They don't have the power of enforcement of their own.
Thank you so much. We have just a few minutes left. And so perhaps maybe we have one more question. Sadiq, can you ask a question for us, please? Before we move on to the poll.
Just a moment. Okay, there is this question by Mr. Mahmoud Abbajato. Can state-owned enterprises like the Nigerian National Petroleum Company Limited be brought under the jurisdiction of the ICSID Convention, considering the distinction between commercial transaction and sovereign investment activities that may not be fully covered by the New York Convention? I have projected it.
Thank you. Mr. Lange, would you like to weigh in on this?
I shudder to think about in what circumstance. But what I would say is, of course, when you're talking about ICSID, those are primarily investor-state matters, investor-state disputes, right? And when the question says matters that are not, whether an NPC could be, so I think because the last bit, my understanding, of course, is that you have an NPC as a commercial entity, and you typically would enter into contracts with parties, whether it's production sharing contracts or service contracts and what have you. And those provisions of the contract, because they are purely commercial contracts, have provisions for dispute resolution, whether by way of arbitration or litigation or what have you. So commonly they will go before commercial arbitration, and tribunals will be effectively able to handle those matters. So that's why I said I don't understand what distinction is being drawn in that question. Typically, for matters of NNPC, because they are dealing with commercial contracts, they can go depending on what that dispute resolution clause says. But when it concerns, if there are questions about, for example, a state exercise of their sovereign rights, you then have to go into the realm of, for example, whether you go to litigation, if you're an investor that does not have a treaty, a bilateral investment treaty with Nigeria or any other country that you're dealing with. But if you do have one, then those provisions typically allows you to go for investor state arbitration under the ICSID umbrella.
If you like, I would like to add something to that. So if NNPC, for example, has a contract with another country in the framework of an investment contract, I think it's also possible for them to be before the ICSID to resolve their dispute in front of the ICSID. So in the case of a contract between the Nigeria-owned company, NNPC, say, and other state, for example, in the framework of a contract, it also be possible.
Thank you so much for that. And just as a follow-up, in a commercial contract, just to be sure that I just want to clarify, Dr. Tosa, when you refer to maybe NNPC entering into a contract with another body, are we talking about a commercial contract here? And not...
No, I'm not talking about a commercial contract. It should be an investment contract.
Good. Yeah, I just wanted to be sure. Yeah. Okay, fantastic. Thank you so much. Sadiq, can we please move on to the polls? We have just about 4 minutes left before we wrap up. So to discuss the results of the polls and then say our goodbyes. Thank you.
Okay, let's continue from where we stopped. Look at how our participants think about our questions. The gray zones, like one of our speakers spoke about, which gray area disputes cause the greatest uncertainty on arbitrability in your jurisdiction? So the most voted answer is the securities and financial markets disputes. Any thoughts on that, Anne-Marie? Any question? Any addition, sorry, from our speakers on this?
Security and financial matters.
Yeah.
Yeah.
Yeah, I mean, I think more, as a matter of fact, I actually think that until recently, financial matters, parties tend to not even want to put um, arbitration in the dispute. For example, when you will see that in banking dispute, for example, they tend to want to do litigation. Of course, some of them also, because many of the transactions are the international ones are cross-border. They look for countries that have an effective state court system that mitigate against the delays in some courts that are slow, because of the fact that enforcement, because of the fact that the state courts have powers to make different orders. Most times, because those orders need to affect third parties, which a tribunal cannot make. So I do agree with that vote.
Thank you
so
very much.
So maybe we have one
Ms.
more.
Ann, I think the time.
Yes, we have
Time is-
perhaps, yeah, maybe one
We
more.
don't have Dr. Esan, your mic is muted.
Oh, sorry.
We don't have more time.
More time.
No more time.
Yeah.
Thank you. Thank you so much.
Sorry about
So just to wrap up, I think I'm struggling a little bit here. Hello?
Yeah, we can hear you.
Okay, fantastic. Yeah. So just to wrap up,
Yes.
we've discussed the issues of arbitrability and maybe some of the public policy concerns that it raises. And we've also discussed drafting arbitration clauses so as to avoid falling into the trap of non-arbitrability. I guess my key takeaways would be that to avoid arbitrability as a ground for setting aside an award, we must use clear, consistent, sort of mandatory identifiable language, and avoid pathological clauses, so that in the course of drafting arbitration clauses. Also, you have to make sure that the subject matter is arbitrable, and that has to be in compliance with perhaps maybe the law of the arbitration agreement or the law of the seat of the arbitration as well. So we check from both areas. Thank you so much to our esteemed panelists and to you, our audience as well. Thank you, Madam Chair. And thank you to our coordinator, Sadiq. It has been an amazing experience. I hope everybody has learned something.
Thank you, Ms. Ann. Before
Sure.
we go,
Thank
it's my honor to invite the chair of the Chartered Institute of Arbitrators Nigeria branch, Mrs. Olusola Adegbomire, FCAI, to give us the vote of thanks and close the session for us. Thank you, everyone. Thank you very much. Thank you, Ms. Ann.
Thank you very much. I hope you can hear me.
Yes, ma'am, we
Yes.
can.
Okay, thank you very much. This has been another very interesting webinar. I mean, I thought I knew everything about this, but even I learned one or two things. This has been very interesting. I don't know how the committee comes up with the themes or the topics for these webinars, but each one is very interesting. This one has been too. I want to thank everybody. First of all, the committee putting the webinar together, the speakers. I mean, you've done an amazing job. You obviously just didn't come to, well, let's see how it goes. I can see that you've done a lot of research and the preparing for it, the moderator, and Maria and Sadiq, you've been great. You know, the polls, I mean, this has been very interesting. I just want to say thank you very much, Dr. Esan and Madam Lewa, well done, and the rest of the committee. Thank you very much. I'm already looking forward to the next one. I think this one, for about 3 days, I put it on reminder. Then I called my office. I said, remind me because I must not miss this one. And I'm sure everybody who has attended has found it interesting. These are the things that we are enjoying in the Chartered Institute of Arbitrators. So please, not just attend the webinars, join the institute, especially if you are corporate, commercial oriented. I mean, I'm sure from this webinar, some people have learned that you can't really arbitrate marital disputes, at least in Nigeria, criminal matters and other parts of the world. Sometimes things will change. And then, you know, I like the fact that it was being referred to in one country, in another country. And I think sorry to take time, but I think the committee, because you always seem to bring people from other parts of the world, which gives us a very broad global view to a lot of the topics, or to all the topics that the committee brings. So thank you very much. This one has been very interesting. Thank you again to our speakers and to all the participants. Thank you, because all this is for the participants. And if we had no participants, then there'd be no point having a webinar. So to everyone who has attended, given 1.5 hours of your time, thank you very much for attending. The committee will keep having these webinars and we will keep learning more. So, Anne-Marie, Ghana, I don't even know what part of the world you are in, and so many other people. Thank you so much. Thank you.
Thank you. Thank you, Madam
Just
Chair.
brings
Thank
it to
you
the end
so
of
much.
my thank you. Thank you so much.
Thank you once again, everyone.
Thank you for all your support. Thanks, everyone.
Mrs. Lewa, everybody. Thank
Bye,
you.
everyone.
Bye-bye.